criminal defense attorney and former Miami-Dade County prosecutor, alongside Richard Schoenstein, trial lawyer and legal analyst. Gentlemen, thank you so much for joining me today.
Good to be here.
Mark, let's just jump right into this there, because you know that this is a moment in history, like Joe started off by saying this. Are we surprised by this verdict, and what happens now?
It's not surprising at all. He didn't go to trial because he wanted to. He went to trial because he had to. This Trump appointee judge did not accept the plea bargain that was worked out between the prosecutors and the defense lawyers. So then he was forced to go to trial. The evidence he knew, and we all knew, was overwhelming that at the time he was knee-deep in addiction. He was smoking crack every 20 minutes. And even if there was a brief stint where he wasn't, involved in drugs, he was an addict. So he had every obligation to put down on that form, yes, I'm an addict, or yes, I am using. The argument made by the defense lawyer didn't resonate with the 12 jurors, that his truth was that I was not an addict at the time because I was knee deep in my own denial of my addiction. That didn't work. And so he was convicted. Not a surprise at all.
Richard, was it a mistake for Hunter not to take the stand, or would that have only dug a deeper hole for him?
I don't see any reason he would have wanted to take the stand. He would have been cross-examined on so many things. That wouldn't have helped him at all. I totally agree with Mark. On the law and on the evidence, this conviction is entirely understandable. It's regrettable, I think, to prosecute a recovering addict for stuff he did while he was an addict. Those who have gone through addiction know it's the only disease that tells you you don't have a disease. And that might have been an argument he could have made at his trial, but I understand what the jury did here.
Richard, one of the things that was mentioned when the jury was selected is that many of those on the jury had a personal experience with addiction, either in their own family or by proxy, someone that they knew. Does it seem as though that was not weighed into their decision, Richard, or it possibly was?
Well, I assume it was. Jurors weigh everything into their decision. They weigh in the evidence. They weigh in the judge's instruction on the law. They weigh in their life experiences. Being a recovering addict doesn't mean you get a free pass. You still have to take responsibility for the things you did. And the jurors probably felt, given the way the law was explained to them and given the evidence, they had to hold him responsible.
Mark, so many say that this case never should have gotten this far. Is that true? Or, Mark, do you just want to poke a pin in that right now and say, no, there was every reason to bring this case forward and justice needed to be vetted out?
Look, I'm not going to criticize prosecutors for bringing a case where somebody actually lied on a form. Again, that's what the jurors found. And they did so at a time to secure a dangerous weapon. What I do take exception to is, why didn't the judge allow this case to be resolved the way the prosecutors chose it to be resolved, where they would have dropped the charges here and he would have pled to the tax evasion? What I'm concerned about moving forward is if the prosecutors ask for a single day in jail. That would be intellectually dishonest. At one moment, they're saying you could drop the charges. Now they're going to ask for prison time. Certainly, I hope that they're going to stay true to how they felt about this case initially when they were before the judge and the judge rejected the offer.
And Mark, but we're about 120 days out from when the judge says he'll actually put out a sentence. Is this a situation where first-time offender, we're looking at no jail time, or, as you suggested, possibly just 1 day in jail, but something that will serve as some type of incarceration?
It depends, first of all, how the pre-sentence investigation report comes back. Considering the unique nature of his background in this offense, they'll come up with a guideline range. That's the first thing. The judge doesn't have to sentence him within the guideline range, assuming it calls for a minimum amount of prison. The judge can deviate downward. But I certainly hope and expect that there isn't a trial tax. Judges don't talk about it, but we all know, Richard knows as a trial lawyer, what a trial tax is. You go to trial, and I'm going to punish you for it. Now, they'll never say it on the record, but it's a message to all the other people considering plea bargains. If you go to trial, you're going to be held accountable worse than had you simply taken the plea.
And from what I understand, as a layperson, not an attorney at all, Richard, what Mark is saying is hey, don't waste our time with this. You could have taken care of this before you brought this to me. But now that you are wasting taxpayers' dollars, I feel I'm going to really stick it to you.
He's 100% right. I mean, that's why you do a plea bargain, is because generally there's less punishment if you plea out than if you take the case to trial. But this defendant is remorseful. Again, he's a recovering addict. It's a nonviolent offense. It's a first-time offense. He's not a risk to anybody. There are so many reasons that he should be given a pretty light sentence in this case.
And Richard, so much is laid and talked about behavior in the courtroom and how it should or should not matter those who are there to support a defendant. Will this weigh into the judge's sentencing guidelines, you believe at all? The fact that the First Lady was seated there, the fact that his family was there, the fact that his daughter broke down on the stand when she had to testify against her father. Does the judge weigh these things, Richard, when he's thinking about a possible sentence?
I think the judge will weigh the testimony of the family members. I don't think the judge will weigh the presence of the family members. That's not something that would probably enter into the reasoning of the judge in sentencing, but certainly the testimony, certainly the fact that he has a family, that he has a loving and supportive family, those are things that the judge can and should consider.
And Richard, before I let you go quickly, and Mark, same question, what is the biggest takeaway from this historic moment? Richard.
Well, for me, the biggest takeaway is, the judicial system works. Whether or not you like these charges, this went to a jury. Nothing was rigged. Nothing was fixed. Here we have another jury considering the evidence, considering the judge's instruction, and rendering a decision. And agree with the prosecution or not, it's a judicial system at work.
Mark?
I agree with Richard, and I'll add that the Bidens had home court advantage, everybody was saying, because this is Delaware and they're loved by people in that state. It goes to show you that jurors generally get it right. If there was that feeling amongst them, they pushed it aside, they focused on the facts, and they said, yeah, he's guilty.
And they looked at the evidence in front of them. Mike Eiglarsh, Richard Schoenstein, thank you both for joining us this day on this breaking news and historic moment. Thank you both. Joining us now on the phone is NewsNation political editor, host of The Hill Sunday, Chris Stirewell. Chris, good afternoon.
Good afternoon.
Chris, you've been watching all of this unfold just like we all have, and we're just trying to really wrap our heads around a moment in history. Chris?
Well, it is a moment in history, but it's also